The Louisiana Division of Historic Preservation, in partnership with the Louisiana Trust for Historic Preservation, are pleased to provide an overview of the Section 106 review process. Grounded in the National Historic Preservation Act of 1966, the Advisory Council on Historic Preservation is authorized to issue regulations to govern the implementation of the Section 106 review process per 36 CFR Part 800, Protection of Historic Properties. This process requires federal agencies to consider the impact of their actions on historic properties and provide the Advisory Council an opportunity to comment on projects before implementation. Because of Section 106, federal agencies must assume responsibility for the consequences of their actions on historic properties and be publicly accountable for their actions. Be mindful, Section 106 encourages but does not mandate preservation. The federal agency's role is clear. The requirements of Section 106 extend to all agencies of the executive branch. A federal agency's responsibility to comply with Section 106 cannot be delegated to others, with very few exceptions specified by federal statute. The Department of Housing and Urban Development is permitted by statute to delegate its 106 responsibilities to local governments in certain programs. In addition, each agency is required by Section 110C of the National Historic Preservation Act to have a federal preservation officer to coordinate the agency's activities and compliance responsibilities. Who are the key players in the Section 106 review process? The federal agency's role has previously been mentioned. The Advisory Council on Historic Preservation, or ACHP, is charged with historic preservation leadership within the federal government. They are an independent federal agency which promotes programs and policies that impact historic properties. They also advise the President and Congress about historic preservation matters and educate stakeholders and the public. The State Historic Preservation Officer, or SHPO, play an essential role in the review of federal undertakings and is a consulting party. The Tribal Historic Preservation Officer, or THPO, represents a federally recognized tribe and must be consulted when a project occurs on or affects historic properties on tribal land or on ancestral homelands. If there is no THPO, the agency must consult with the designated representative of the tribe. Be mindful, a federal agency cannot delegate tribal consultation with Indian tribes. They must engage in government-to-government consultation. Next, local and state governments are entitled to participate when a project affects properties under their jurisdiction. Organizations and individuals, such as neighborhood associations or property owners, may have an interest in a project and are entitled to participate. The public must be provided with an opportunity to learn about a project, its effects on historic properties, and to express their views. There are 4 essential steps in the Section 106 review process designed to ensure compliance and transparency. The agency must explore measures to avoid, minimize, or mitigate adverse effects. The second step in the process, identify historic properties, per 36 CFR 800.4, requires that the agency gather information to decide which properties in the project area are listed in or eligible for the National Register of Historic Places. When identifying historic properties, the agency must ensure that their staff or consultant meets Secretary of the Interior's professional qualification standards for archaeology and/or historic preservation and are able to appropriately apply National Register criteria for evaluation. First, the agency must initiate the 106 process per 36 CFR 800.3. They must establish the undertaking. To do so, 2 criteria for action must be met. 1. Is there federal involvement? And 2. Is there a potential for the activity to affect historic properties? If so, how will they be affected? The Louisiana SHPO has a number of resources available to the public to assist them in identifying eligible or listed properties. The Division of Historic Preservation maintains a user-friendly National Register database as well as an interactive map which highlights historic districts and individually listed above and below ground resources where permitted. The Louisiana Division of Archaeology maintains a number of research databases with information that may be helpful in the 106 process. The Louisiana Radiocarbon Database provides radiocarbon dates obtained for archaeological sites. The Louisiana Cultural Resource Management Bibliography provides abstracts and bibliographic information for the Library of Cultural Resource Management reports housed in their office. The Excavated Sites Database is a searchable database of sites at which Phase 2 testing and/or Phase 3 excavations have been conducted. The Sites Eligibility Database provides information on sites determined eligible and not eligible for inclusion in the National Register by the SHPO. And finally, the Louisiana Cultural Resources Map is password protected, and it is an online GIS system showing both standing structures and archaeological sites. As part of the agency's identification efforts, they must determine the undertaking's area of potential effects, or APE. Done in consultation with the SHPO, TIPO, or tribal representative, the APE is defined as the geographic area or areas within which an undertaking may directly or indirectly cause alterations in the character or use of historic properties, if any such properties exist. The area of potential effects is influenced by the scale and nature of an undertaking and may be different for different kinds of effects caused by the undertaking. Once the agency determines that historic properties may be affected by an undertaking, the agency proceeds with Step 3 of the Section 106 process per 36 CFR 800.5. They must ascertain the nature of the project's impact on the historic properties by applying the criteria of adverse effects. An adverse effect is found when an undertaking may alter directly or indirectly any of the characteristics of a historic property that qualify the property for inclusion in the National Register in a manner that would diminish the integrity of the property's location, design, setting, materials, workmanship, feeling, or association. Early discussions with the SHPO are encouraged. When an agency is ready to engage in formal consultation with the Louisiana SHPO, a cover letter addressed to the Louisiana State Historic Preservation Officer is required, along with agency involvement, project description, and an effects determination, as well as other information shown here. The SHPO has 30 days to respond when provided with a complete request. After determining that an undertaking may have an adverse effect on historic properties within the area of potential effects, the agency proceeds with Step 4 in the process, Resolution of Effect per 36 CFR 800.6. Consultation to resolve adverse effects may or may not entail a lengthy process, as each undertaking may be different. The result of this consultation process is a Memorandum of Agreement or Programmatic Agreement drafted by the federal agency in consultation with the SHPO, TIPO, tribes, and in some instances with the Advisory Council on Historic Preservation. Members of the public are also consulted. A Memorandum of Agreement, or MOA, is a legally binding document that commits an agency both by statute and by regulation to carry out the undertaking in accordance with the terms of the agreement. Besides binding signatory parties to its stipulations, an MOA provides clear evidence that an agency has met its obligations under Section 106. Properly executing and carrying out the terms of an MOA allows an agency to withstand legal challenges over its compliance with Section 106. Therefore, the MOA has to be legally sufficient and should be drafted with care. Another agreement document that a federal agency may decide to utilize, depending on the nature of the undertaking, is a Programmatic Agreement, or PA. A PA is a legally binding document that may be used to guide multiple or complex undertakings, guide undetermined effects or process, outline a tailored environmental review process, or guide routine management of historic sites or a district. Programmatic agreements also serve as a great tool to streamline Section 106 reviews. They promote efficiency within the realm of 106 for both agency and SHPO or TIPO. They provide clearance for certain types of low-impact projects, eliminating the need for 106 reviews, and they provide prescriptive minimization and mitigation measures when adverse effects are determined. For detailed information on the Section 106 review process, please visit the Advisory Council's website at achp.gov. For more detailed information to assist in the 106 review process pertaining to undertakings in Louisiana, visit the Office of Cultural Development's website and click on the Division of Historic Preservation or Division of Archaeology.